Q. PJ engaged the services of attorney ST to represent him in a civil case filed by OP against him, which was docketed as civil case number 123. A returnership agreement was executed between PJ and attorney ST, whereby PJ promised to pay attorney ST a retainer sum of $24,000 a year and to transfer the ownership of a parcel of land to attorney ST after presentation of PJ's evidence. PJ did not comply with his undertaking. Attorney ST filed a case against PJ, which was docketed as civil case 456. During the trial of civil case number 456, PJ died. Is the death of PJ a valid ground to dismiss the money claims of attorney ST in civil case number 456? Explain. No. Under Section 20, Rule 3, 1997 Rules of Civil Procedure, when the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action is pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiffs shall be enforced in the manner specially provided in the rules for prosecuting claims against the estate of the deceased person. B. Will your answer be the same with respect to the real property being claimed by attorney ST in civil case number 456? 1999, 2000, 2009 bar. Answer: yes. An action to recover real property in any event survives the death of the defendant. Section 1, Rule 87. However, a favorable judgment may be enforced in accordance with Section 7, letter B, Rule 39 against the executor or administrator or successor in interest of the deceased. Q. A filed a complaint for the recovery of ownership of land against B, who was represented by her counsel X. In the course of the trial, B dies. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who, being B's sole heir, acquired the property. If you were the counsel of C, what course of action would you take? 1998. A. As counsel of C, I would move to set aside the writ of execution and the judgment for lack of jurisdiction and lack of due process in the same court, because the judgment is void. If X had notified the court of B's death, the court would have ordered the substitution of the deceased by C, the sole heir of B. Section 16, Rule 3. The court acquired no jurisdiction over upon C, whom trial and the judgment are not binding. Ferreira versus Ibarra. VDA D. Gonzalez. GR 11567. I could also file an action to annul the judgment for lack of jurisdiction because C, as the successor of B, was deprived of due process and should have been heard before judgment. Rule 47. Q. Prince Chong entered into a lease contract with King Kong over a commercial building where the former conducted his hardware business. The lease contract stipulated, among others, a monthly rental of 50,000 pesos for a 4-year period commencing on January 1, 2010. On January 1, 2013, Prince Chong died. King Kong was appointed administrator of the estate of Prince Chong, but the former failed to pay the rentals for the months of January to June 2013, despite King Kong's written demands. Thus, on July 1, 2013, King Kong filed with the Regional Trial Court an action for rescission of contract with damages and payment for accrued rentals as of June 30, 2013. A. Can King Kong move to dismiss the complaint on the ground that RTC is without jurisdiction since the amount claimed is only $300,000? Answer: no. King Kong cannot move to dismiss the complaint. An action for rescission of contract with damages and payment of accrued rentals is considered incapable of pecuniary estimation and therefore cognizable by the regional trial court. Cafarina de Hungría v. Court of Appeals, July 25, 2011. B. If the rentals accrued during the lifetime of Prince Chong and King Kong also filed a complaint for a sum of money during that time, will the action be dismissible upon Prince Chong's death during the pendency of the case, 2014? No, the action will not be dismissible upon Prince Chong's death during the pendency of the case. When the action is for recovery of money arising from contract, the defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced under Rule 86, Section 20, Rule 3. Relative thereto, since the complaint for sum of money filed by King Kong survives the death of Prince Chong, the case shall not be dismissed, and the court shall merely order the substitution of the deceased defendant. Attorney Rogelio Sarsaba v. Fe Vidie Dite, July 30, 2009. Venue. Q. Distinguished jurisdiction from venue, 2006. A. Jurisdiction is the power of the court to decide a case on the merits, while venue refers to the place where the suit may be filed. In criminal actions, however, venue is jurisdictional. Jurisdiction may not be conferred upon a court by consent through waiver, but venue may be waived except in criminal cases. Q. Angela, a resident of Quezon City, sued Antonio, a resident of Makati City, before the RTC of Quezon City for the reconveyance of 2 parcels of land situated in Tarlac and Nueva Ecija, respectively. May her action prosper, assuming that the action was for foreclosure on the mortgage of the same parcel of land? What is the proper venue for the action? 2008. Answer: yes. The action may prosper because improper venue can be waived, and there appears to be no objection from the defendant. An action for reconveyance of parcels of land partakes of an action to recover title to or possession of such land. Hence, a real action, which should be filed in the place where the parcels of land are situated in Tarlac and Nueva Ecija. If the action was for foreclosure of mortgage, the action may be filed either in Tarlac or Nueva Ecija, where any of the parcels of land is situated. Only one action for foreclosure need be filed as only one contract had been instituted. Bank of P.I. v. Green, December 12, 1932. Q. A law was passed declaring Mount Carbunco as a protected area since it was a major watershed. The protected area covered a portion located in municipality of A of the province I and a portion located in the city of C of province 2. Maingat is the leader of Samahan ng Tagapag-ingat ng Carbunco, STK, a people's organization. He learned that a portion of the mountain located in the city of Z of province of 2 was extremely damaged when it was bulldozed and leveled to the ground, and several trees and plants were cut down and burned by workers of World Pleasure Resorts Incorporated, WPRI, for the construction of a hotel and golf course. Upon inquiry with the project site engineer if they had a permit for the project, Maingat was shown a copy of the Environmental Compliance Certificate, or ECC, issued by the DNR-EMB, Regional Director, RD DNR-EMB. Immediately, Maingat and STK filed a petition for the issuance of a writ of continuing mandamus against RD DNR-EMB and WPRI with the RTC of Province I. a designated environmental court, as the RD-DNR EMB negligently issued the ECC to WPRI. On scrutiny of the petition, the court determined that the area where the alleged actionable neglect or omission subject of the petition took place in the city of C of Province 2, and therefore cognizable by the RTC of Province 2. Thus, the court dismissed outright the petition for lack of jurisdiction. Was the court correct in motu proprio dismissing the petition? Answer is no. The court was not correct in motu proprio dismissing the petition. While it appears that the alleged actionable neglect or omission took place in the city of Z of Province 2, and therefore cognizable by the RTC of Province 2, nonetheless, venue is not jurisdictional, and it can be waived in a special civil action for continuing mandamus, Dolot v. Honorable Paje, August 27, 2013. Besides, under Section 1, Rule 9 of the Rules of Court, defenses and objections not pleaded in the answer or in the motion to dismiss are deemed waived. Hence, the court cannot motu proprio dismiss the case on the ground of improper venue. Q. Assuming that the court did not dismiss the petition, the RD-DNR EMB in this comment moved to dismiss the petition on the ground that petitioners failed to appeal the issue of the ECC and to exhaust administrative remedies provided in the DNR Rules and Regulations. Should the court dismiss the petition? 2015. Yes, the court should dismiss the petition because the proper procedure to question defect in an ECC is to follow the DNR administrative appeal process in accordance with the doctrine of exhaustion of administrative remedies, Dolot v. Honorable Paje. Paje v. Casino. Effects of stipulations on venue. Q. X, a resident of Angeles City, borrowed 300,000 pesos from A, a resident of Pasay City. In the loan agreement, the parties stipulate that the parties agree to sue and be sued in the city of Manila. A. In case of non-payment of the loan, can A file his complaint to collect the loan from X in Angeles City? The answer is yes, because the stipulation in the loan agreement that the parties agree to sue and be sued in the city of Manila does not make Manila the exclusive venue thereof, Section 4, Rule 4. Hence, A can file his complaint in Angeles City, where he resides, Section 2, Rule 4. Letter B. Suppose the parties did not stipulate in the loan agreement as to the venue, where can A file his complaint against X? If the parties did not stipulate in the venue, A can file his complaint either in Angeles City, where he resides, or in Pasay City, where X resides. C. Suppose the parties stipulated in their loan agreement that venue for all suits arising from this contract shall be the courts in Quezon City. Can A file his complaint against X in Pasay City? 1997. Answer is no. If the parties stipulated that the venue shall be in the courts in Quezon City, A cannot file his complaint in Pasay City because the use of the word shall makes Quezon City the exclusive venue thereof. Hersht, Philippines versus Torres. GR number L44351, May 18, 1978. Rules on pleadings. Q. What is counterclaim? Distinguish a counterclaim from a cross-claim. 1999. Answer. A counterclaim is distinguished from a cross-claim in that a cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. A counterclaim is against an opposing party, while a cross-claim is against a co-party. Section 8, Rule 6. Q. A, who is engaged in tile installation business, was sued by EE Industries for breach of contract for installing different marble tiles in its offices as provided in their contract. Without filing any motion to dismiss, A filed its answer with counterclaim theorizing that EE Industries has no legal capacity to sue because it is not a duly registered corporation. By way of counterclaim, A asked for moral and actual damages as her business depleted as a result of the withdrawal and cancellation by her clients of their contracts due to the filing of the case. The case was dismissed after the trial court found that EE Industries is not a registered corporation and therefore has no legal capacity to sue. However, it set a date for the reception of evidence on A's counterclaim. EE Industries opposed on the ground that the counterclaim could no longer be prosecuted in view of the dismissal of the main case. Is the stand of EE Industries sustainable? Explained. 1999. Answer: no. Because of no motion to dismiss has been filed, any of the grounds for dismissal provided in the rules may be pleaded as an affirmative defense in the answer, which may include a counterclaim. This is what A did by filing an answer alleging the lack of legal capacity of EE Industries to sue because it is not a duly registered corporation, with a counterclaim for damages. The dismissal of the complaint on this ground is without prejudice to the prosecution of the counterclaim in the same action because it is a compulsory counterclaim. Section 6, Rule 16. Q. Fe filed a suit for collection of $387,000 against Ramon in the RTC of Davao City. Aside from alleging payment as a defense, Ramon in his answer set up counterclaims for 100,000 pesos as damages and 30,000 pesos as attorney's fees as a result for the baseless filing of the complaint, as well as for 250,000 as the balance of the purchase price of the 30 units of air conditioners he sold to Fe. A. Does the RTC have jurisdiction over Ramon's counterclaims? And if so, does he have to pay docket fees, therefore? Answer is yes. The RTC has jurisdiction over Ramon's counterclaims because they are all money claims in which the totality rule applies in determining jurisdiction. Ramon has to pay docket fees for his counterclaims, whether counterclaim is compulsory or permissive in nature. Rule 141 of the Rules of Court has been amended to require payment of docket fees for counterclaims and cross-claims, whether compulsory or permissive. Section 5, letter D, Rule 2. B. Suppose Ramon's counterclaim for the unpaid balance is 310,000 pesos. What will happen to his counterclaims if the court dismisses the complaint after holding a preliminary hearing on Ramon's affirmative defenses? A. The dismissal of the complaint is without prejudice to the right of the defendant, Ramon, to prosecute his counterclaim in the same or in a separate action. Section 6, Rule 16, last paragraph. Pinga v. Ears of Santiago, June 2006. C. Under the same premise as paragraph B above, suppose that instead of alleging payment as a defense in his answer, Ramon filed a motion to dismiss on the ground that, at the same time setting up his counterclaims, and the court grants his motion, what will happen to his counterclaims? 2008. Answer. Since Ramon filed only a motion to dismiss, not an answer, the dismissal of the complaint would also bring about the dismissal of his counterclaims, but he can file a separate action for his permissive counterclaims. The compulsory counterclaims are deemed waived when he filed a motion to dismiss the complaint instead of answering the same. Financial Building Corporation versus Forbes Park Association, August 17, 2000. Q. Antique dealer Mercedes borrowed $1 million from antique collector Benjamin. Mercedes issued a post-dated check in the same amount to Benjamin to cover the debts. On the due date of the check, Benjamin deposited it, but it was dishonored. As despite demands, Mercedes failed to make good the check. Benjamin filed on January 2009 a complaint for collection of sum of money before the RTC of Davao. Mercedes filed in February 2009 her answer with counterclaim, alleging that before the filing of the case, She and Benjamin had entered into a dacian and pago agreement in which her vintage 1 million Rolex watch, which was taken by Benjamin for sale on commission, was applied to settle her indebtedness, and that she incurred expenses in defending what she termed a frivolous lawsuit. She accordingly prayed for 50,000 damages. A. Benjamin soon after moved for the dismissal of the case. The trial court accordingly dismissed the complaint, and it also dismissed the counterclaim. Mercedes moved for reconsideration of the dismissal of the counterclaim. Passed upon Mercedes' motion. Answer. Mercedes' motion for reconsideration is impressed with merit. The trial court should not have dismissed her counterclaim despite the dismissal of the complaint, since it was the plaintiff Benjamin who moved for the dismissal of his complaint, and at the time when the defendant Mercedes had already filed her answer thereto, and with counterclaim. The dismissal of the complaint should not carry with it the dismissal of the counterclaim without the conformity of the defendant counterclaimant. The revised rules of court provides in Rule 15, Section 2 thereof, that if a counterclaim has been pleaded by a defendant prior to the service upon him of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his counterclaim. B. Suppose there was no counterclaim and Benjamin's complaint was not dismissed, and judgment was rendered against Mercedes for 1,000,000 pesos. The judgment became final and executory, and a writ of execution was correspondingly issued. Since Mercedes did not have cash to settle the judgment debt, she offered her Toyota Camry Model 2008, valued at 1.2 million. The sheriff, however, on request of Benjamin, seized Mercedes' 17th century ivory image of the La Sagrada Familia, estimated to be worth over 1 million. Was the sheriff action in order? 2010. Answer: no. The sheriff's action was not in order. He should not have listened to Benjamin, the judgment obligee or creditor, in levying on the properties of Mercedes, the judgment obligor or debtor. The option to immediately choose which property or part thereof may be levied upon, sufficient to satisfy the judgment, is vested by law, Rule 39, Section 9, letter B, upon the judgment obligor, Mercedes, not upon the judgment obligee, Benjamin. In this case, only if the judgment obligor does not exercise the option is the sheriff authorized to levy on personal properties, if any, and then on the real properties if the personal properties are insufficient to answer for the judgment. Q. The plaintiff sued the defendant in the RTC for the damage allegedly caused by the latter's encroachment of the plaintiff's lot. In his answer, the defendant denied the plaintiff's claim and alleged that it was the plaintiff who in fact had encroached on his defendant's land. Accordingly, the defendant counterclaimed against the plaintiff for damages resulting from the alleged encroachment on his lot. The plaintiff filed an ex parte motion for extension of time to answer the defendant's counterclaim, but the court denied the motion on the ground that it should have been set for hearing. On the defendant's motion, therefore, the court declared the plaintiff in default on the counterclaim. Was the plaintiff validly declared in default? Why? 2002. No, the plaintiff was not validly declared in default. A motion for extension of time may be filed ex parte and need not be set for hearing. Amante v. Sunga, May 28, 1975. Q. PX filed a suit for damages against DY. In his answer, DY incorporated a counterclaim for damages against PX and AC, counsel for plaintiff in said suit, alleging in said counterclaim inter alia that AC as such counsel maliciously induced PX to bring the suit against DY, despite AC's knowledge of its utter lack of factual and legal basis. In due time, AC filed a motion to dismiss the counterclaim as against him on the ground that he is not a proper party to the case. he being merely plaintiff's counsel. Is the counterclaim of DY compulsory or not? Should Ace's motion to dismiss the counterclaim be granted or not? Reason 2004. Yes. The counterclaim of DY is compulsory because it is one which arises out of or is connected with the subject matter of the opposing party claim, and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Section 7, Rule 6. The motion to dismiss of plaintiff's counsel should not be granted because bringing in plaintiff's counsel as a defendant in the counterclaim is authorized by the rules, where it is required for the grant of complete relief in the determination of the counterclaim. The court shall order the defendant's counsel to be brought in since jurisdiction over him can be obtained. Rule 6, Section 12, Aurelio v. Court of Appeals. Here, the counterclaim was against both the plaintiff and his lawyer, who allegedly maliciously induced the plaintiff to file the suit. Q. B and C borrowed 400,000 pesos from A. The promissory note was executed by B and C in a joint and several capacity. B, who received the money from A, gave C 200,000 pesos. C in turn loaned 100,000 pesos out of the 200,000 he received to D. A, in an action filed by A against B and C with the RTC of Quezon City, can B file a cross-claim against C for the amount of 200,000 pesos? Yes, B can file a cross-claim against C for the amount of 200,000 pesos given to C. A cross-claim is a claim filed by one party against a co-party arising out of the transaction or occurrence that is the subject matter of the original action or a counterclaim therein, and may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of a claim asserted against the cross-claimant. Section 8, Rule 6. B. Can C file a third-party complaint against D for the amount of 100,000 pesos, 1997? Answer is no. C cannot file a third-party complaint against D because the loan of 100,000 pesos has no connection with the opponent's claim. C could have loaned the money out of other funds in his possession. Q. J.K.'s real property is being attached by the sheriff in a civil action for damages against L.M. J.K. claims that he is not a party to the case, that his property is not involved in said case, and that he is the sole registered owner of said property. Under the rules of court, what must J.K. do to prevent the sheriff from attaching his property? 2,000. A. If the real property is being attached, the remedy is to file a third-party claim. The third-party claimant should make an affidavit of his title to the property attached, stating the grounds of his title thereto, and serve such affidavit upon the sheriff while the latter has possession of the attached property, and a copy thereof upon the attaching party. Rule 57, Section 14. The third-party claimant may also intervene or file a separate action to vindicate his claim to the property involved and secure the necessary reliefs, such as preliminary injunction, which will not be considered as interference with the Court of Coordinate Jurisdiction. Ong versus Tating, April 15, 1987. Q. A obtained a money judgment against B. After the finality of the decision, the court issued a writ of execution for the enforcement thereof. Conformably with the said writ, the sheriff levied upon certain properties under B's name. C filed a third-party claim over said properties, claiming that B had already transferred the same to him. A moved to deny the third-party claim and to hold B and C jointly and severally liable to him for the money judgment, alleging that B had transferred said properties to C to defraud him. A. After due hearing, the court denied the third-party claim and rendered an amended decision declaring B and C jointly and severally liable to A for the money judgment. Is the ruling of the court correct? Explained, 2005. No. C has not been properly impleaded as a party defendant. He cannot be held liable for the judgment against A without a trial. In fact, since no bond was filed by B, the sheriff is liable to C for damages. C can file a separate action to enforce his third-party claim. It is in this suit that B can raise the ground of fraud against C. However, the execution may proceed where there is a finding that the claim is fraudulent. Tonongan v. Samson, May 9, 2002. Q. X files a complaint in the RTC for the recovery of a sum of money with damage against Y. Y files his answer denying liability under the contract of sale and praying for the dismissal of the complaint on the ground of lack of cause of action because the contract of sale was superseded by contract of lease executed and signed by X and Y 2 weeks after the contract of sale was executed. The contract of lease was attached to the answer. X does not file a reply. What is the effect of non-filing of a reply? 2000. A. A reply is generally optional. If it is not filed, the new matters alleged in the answer are deemed controverted. Section 10, Rule 6. However, since the contract of lease attached to the answer is the basis of the defense, by not filing a reply denying under oath the genuineness and due execution of said contract, the plaintiff is deemed to have admitted the genuineness and the due execution thereof. Sections 7 and 8, Rule 8, Toribio v. Bidin. Verification and certification against forum shopping. What is forum shopping? 2006. A. Forum shopping is the act of filing multiple suits involving the same parties for the same cause of action, either simultaneously or successively for the purpose of obtaining a favorable judgment. Executive Secretary v. Gordon. Q. Honey filed with the Regional Trial Court, Taal, Batangas, a complaint for specific performance against Bernie. For lack of certification against forum shopping, the judge dismissed the complaint. Honey's lawyer filed a motion for reconsideration, attaching thereto an amended complaint with a certification against forum shopping. If you were the judge, how will you resolve the motion? 2006. If I were the judge, the motion should be denied after hearing because, as expressly provided in the rules, failure to comply with the requirement of forum shopping is not curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for dismissal of the case without prejudice, unless otherwise provided. Section 5, Rule 7. However, the trial court, in the exercise of its sound discretion, may choose to be liberal and consider the amendment as substantial compliance. Great Southern Maritime Services versus Acuna. Q. As counsel for A, B, C, and D, attorney XY prepared a complaint for recovery of possession of a parcel of land against Z. Before filing the complaint, XY discovered that his clients were not available to sign the certification of non-forum shopping. To avoid further delays in the filing of the complaint, XY signed the certification and immediately filed the complaint in court. Is XY justified in signing the certification? 2000. Answer: no. Counsel cannot sign the anti-forum shopping certification because it must be executed by the plaintiff or principal party himself. Section 5, Rule 7. Since the rule requires personal knowledge by the party executing the certification, unless counsel gives a good reason why he is not able to secure his client's signatures and shows that his clients will be deprived of substantial justice, Ortiz v. Court of Appeals, or unless he is authorized to sign it by his clients through a special power of attorney. Q. Mr. Humpty filed with the Regional Trial Court a complaint against Ms. Dumpty for damages. The RTC, after due proceedings, rendered a decision granting complaint and ordering Ms. Dumpty to pay damages to Mr. Humpty. Ms. Dumpty timely filed an appeal before the Court of Appeals, questioning the RTC decision. Meanwhile, the RTC granted Mr. Humpty's motion for execution pending appeal. Upon receipt of the RTC's order granting execution pending appeal, Ms. Dumpty filed with the CA another case, this time a special civil action for certiorari, assailing said RTC order. Is there a violation of the rule against forum shopping considering that two actions emanating from the same case with the RTC were filed by Ms. Dumpty with the CA? Explained 2014. No, there is no violation of the rules against forum shopping. The essence of forum shopping is the filing of a party against whom an adverse judgment has been rendered in one form, seeking another and possibly favorable opinion in another suit other than by appeal or special civil action for certiorari. The act of filing of multiple suits involving the same parties for the same cause of action, either simultaneously or successively, for the purpose of obtaining a favorable judgment. Forum shopping exists where the elements of litis pendentia are present, or where a final judgment in one case will amount to res judicata in the action under consideration. Roberto Benedicto versus Lacson. In Philippines Nails and Wires Corporation versus Malayan Insurance Company, February 14, 2003, the Supreme Court held that one party may validly question a decision in irregular appeal and at the same time assail the execution pending appeal by certiorari without violating the rule against forum shopping. This is because the merits of the case will not be addressed in the petition dealing with the execution and vice versa. Since Ms. Dumpty merely filed a special civil action for certiorari, the same will not constitute a violation of the rules on forum shopping because the resolution of a favorable judgment thereon will not amount to res judicata in the subsequent proceedings between the same parties. The same case, GR 141508, May 5, 2010. Q. Taylor's Toto, Nelson, and Yen Yen filed a special civil action for certiorari under Rule 65 from an adverse decision of the National Labor Relations Commission on the complaint for illegal dismissal against Expire Textile Corporation. They were terminated on the ground that they failed to meet the prescribed production quota at least 4 times. The NLRC decision was assailed in a special civil action under Rule 65 before the Court of Appeals. In the verification and certification against forum shopping, only Toto signed the verification and certification, while attorney Arman signed for Nelson. Empire filed a motion to dismiss on the ground of defective verification and certification, decide with reason, 2016. The motion to dismiss should be granted. The verification and certification against non-forum shopping were not signed by all petitioners. There was no showing that Toto nor our attorney Arman were duly authorized by the other petitioners through a special power of attorney to sign on their behalf. Hence, the motion to dismiss should be granted. Alternative answer: the motion to dismiss should be denied because there is substantial compliance of the requirements of the rules. Verification is not a jurisdictional but merely a formal requirement which the court may motu proprio direct a party to comply with or correct as the case may be. On the other hand, regarding the certificate of non-forum shopping, the general rule is that all the petitioners or plaintiffs in a case should sign it. However, the Supreme Court has time and again stressed that the rules on forum shopping, which were designed to promote the orderly administration of justice, do not interdict substantial compliance with its provision under justifiable circumstances. As ruled by the court, the signature of any of the principal petitioners or principal parties would constitute a substantial compliance with the rule on verification and certification of non-forum shopping, and should there exist a commonality of interest among the parties, or where the parties file the case as a collective raising only one common cause of action or presenting a common defense, then the signature of one of the petitioners or complainants acting as representative is sufficient compliance. Irene Marcos, Araneta versus Court of Appeals. Evidently, since there is a commonality of interest among Taylors, Toto, Nelson, and Yen Yen, there is substantial compliance with the rules on verification and certification against form shopping. When Toto signed the verification and certification, and Attorney Arman signed the same for Nelson. Allegations in pleading Q. In his complaint for foreclosure of mortgage, to which was duly attached a copy of the mortgage deed, Plaintiff PP alleged inter alia as follows. 1. That defendant DD duly executed the mortgage deed, copy of which is annexed A of the complaint and made an integral part thereof. 2. That to prosecute his complaint, plaintiff contracted a lawyer, CC, for a fee of 50,000 pesos. In his answer, the defendant alleged inter alia that he had no knowledge of the mortgage deed, and he also denied any liability for plaintiff's contracting with a lawyer for a fee. Thus, defendant's answer as to plaintiff allegation number 1 as well as number 2 sufficiently raise an issue of fact. Reason. As to plaintiff's allegation number 1, defendant does not sufficiently raise an issue of fact because he cannot allege lack of knowledge of the mortgage deed, since he should have personal knowledge as to whether he signed it or not, and because he did not deny under oath the genuineness and due execution of the mortgage deed, which is actionable document. As to plaintiff's allegation number 2, defendant did not properly deny liability as to plaintiff's contracting with a lawyer for a fee. He did not even deny for lack of knowledge. Section 10, Rule 8. Q. When may a party be declared in default? What is the effect of an order of default? 1999. A. A party may be declared in default when he fails to answer within the time allowed therefor, and upon motion of the claiming party, with notice to the defending party and proof of such failure. Section 3, Rule 9. The effect of an order of default is that the court may proceed to render judgment, granting the claimant such relief as his pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. The party in default cannot take part in the trial, but shall be entitled to notice of subsequent proceedings. Section 3, letter A, Rule 9. Q. Circe filed with the RTC a complaint for the foreclosure of real estate mortgage against siblings Sisila and Charybdis, co-owners of the property and co-signatories to the mortgage deed. The siblings permanently reside in Athens, Greece. Circe tipped off Sheriff Pluto that Sila is on Balikbayan trip and is billeted by the Century Plaza Hotel in Pasay City. Sheriff Pluto went to the hotel and personally served Sila the summons, but the latter refused to receive summons for Charybdis, as she was not authorized to do so. Sheriff Pluto requested Sila for the email address and fax number of Charybdis, which the latter readily gave. Sheriff Pluto, in his return of the summons, stated that summons for Sila was served personally as shown by her signature on the receiving copy of the summons. Summons on Charybdis was served pursuant to the amendment of Rule 14 by facsimile transmittal of the summons and complaint on defendant's fax number, as evidenced by transmission verification report automatically generated by the fax machine indicating that it was received by the fax number to which it was sent on the date and time indicated therein. Circe, 60 days after her receipt of Sheriff Pluto's return, filed a motion to declare Charybdis in default, as Charybdis did not file any responsive pleading. Should the court declare Charybdis in default? Answer is no. The court should not declare Charybdis or Charybdis in default because there was no proper service of summons. Section 12, Rule 14 of the Rules of Court applies only to a foreign private juridical entity that is not registered in the Philippines and has no resident agent in the country, and not to individuals. The service of summons by facsimile under said rules is therefore defective. A foreclosure of real estate mortgage is a quasi in rem action. Thus, the court can render judgments as long as it has jurisdiction over the rest and any of the modes of extraterritorial service of summons under Section 15 of Rule 12 is complied with prior leave of court. There is unfortunately no showing in the problem that a prior leave of court was obtained before resorting to extraterritorial service of summons. Hence, the service of summons is defective. B. Sila seasonably filed her answer, setting forth therein a defense that Charybdis had paid the mortgage debts, on the premise that Charybdis was properly declared in default. What is the effect of Sila's answer to the complaint? A. Assuming that Charybdis was properly declared in default, the court shall try the case against all defendants upon the answer filed by Sila and render judgment upon the evidence presented. Section 3, letter C, Rule 9. Q. Mario was declared in default, but before judgment was rendered, he decided to file a motion to set aside the order of default. A. What should Mario state in his motion in order to justify the setting aside of the order of default? A. In order to justify the setting aside of the order of default, Mario should state in his motion that his failure to answer was due to fraud, accident, mistake, or excusable negligence, that he has a meritorious defense. Rule 3, letter B, Rule 9. In what form should such motion be? The motion should be under oath. Q. For failure to seasonably file his answer despite due notice, A was declared in default in a case instituted against him by B. The following day, A's mistress, who is working as a clerk in the sala of the judge before whom his case is pending, informed him of the declaration of default. On the same day, A presented a motion under oath to set aside the order of default, on the ground that his failure to answer was due to fraud, and he has a meritorious defense. Thereafter, he went abroad. After his return a week later, with the case still undecided, he received the order declaring him in default. The motion to set aside default was opposed by B on the ground that it was filed before A received notice of his having been declared in default, citing the rule that the motion to set aside may be made at any time after notice, but before judgment. 1999. A. Assuming that the motion to set aside complies with the other requirements of the rule, it should be granted, although such a motion may be made after notice, but before judgment. With more reason, may it be filed after discovery, even before receipt of the order of default. Q. What are the available remedies of a party declared in default? A. Before the rendition of judgment. Before the rendition of judgment, A. He may file a motion under oath to set aside the order of default on the ground of fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. Section 3, letter B, Rule 9. And if it is denied, he may move to reconsider. And if reconsideration is denied, he may file the special civil action of certiorari for a grave abuse of discretion tantamount to lack or excess of the lower court's jurisdiction. Section 1, Rule 65. Or B. He may file a petition for certiorari if he has been illegally declared in default. Example, during the pendency of his motion to dismiss or before the expiration of the time to answer, Matute v. Court of Appeals. B. After judgment but before its finality, and A. After judgment but before its finality, he may file a motion for new trial on the grounds of fraud, accident, mistake, excusable negligence, or a motion for reconsideration on the ground of excessive damages, insufficient evidence, or the decision or final order being contrary to law. And therefore, if the motion is denied, appeal is available under Rule 40 or 41, whichever is applicable. Letter C. After the finality of judgment, 1998-2006. After finality of the judgment, there are three ways to assail the judgment, which are A. A petition for relief under Rule 38 on the grounds of fraud, accident, mistake, or excusable negligence. B. Annulment of judgment under Rule 47 for extrinsic fraud or lack of jurisdiction. Or C. Certiorari if the judgment is void on its face or by the judicial record, Balangkat v. versus Justices of the Court of Appeals. Q. For failure of KJ to file an answer within the reglementary period, the court upon motion of LM declared KJ in default. In due time, KJ filed an unverified motion to lift the order of default without an affidavit of merit attached to it. KJ, however, attached the motion in his answer under oath, stating in said answer his reasons for his failure to file an answer on time, as well as his defenses. Will the motion to lift the order of default prosper? 2000. Yes. There is substantial compliance with the rule. Although the motion is unverified, the answer attached to the motion is verified. The answer contains the motion to lift the order of default, and the affidavit of merit should contain which are the reasons of the movant's failure to answer as well as his defenses. Section 3, letter B, Rule 9. Citibank N.A. versus Court of Appeals. Amendment. Q. Arturo lent $1 million to his friend Robert on the condition that Robert will execute a promissory note for the loan and a real estate mortgage over his property located in Tagaytay City. Robert complied in his promissory note dated September 20, 2006. Robert undertook to pay the loan within a year from its date at 12% per annum interest. In June 2007, Arturo requested Roberto to pay ahead of time, but the latter refused and insisted on the agreement. Arturo issued a demand letter, and when Robert did not comply, Arturo filed an action to foreclose the mortgage. Robert moved to dismiss the complaint for lack of cause of action, as the debt was not yet due. The resolution of the motion to dismiss was delayed because of the retirement of the judge. A. On October 1, 2007, pending resolution of the motion to dismiss, Arturo filed an amended complaint alleging that Robert's debt had in the meantime become due, but that Robert still refused to pay. Should the amended complaint be allowed, considering that no answer has been filed? No. Even though an amendment of complaint before answer is a matter of right, lack of a cause of action at the commencement of the suit is not cured by the accrual of a cause of action subsequent thereto, such that an amendment setting up the after accrued cause of action is not allowed. Swagman, Hotel and Travel. April 8, 2005. Letter B. Would your answer be different had Arturo filed instead a supplemental complaint stating that the debt became due after the filing of the original complaint? 2008. No, because a complaint whose cause of action has not accrued yet when filed does not gain any standing in court, such that no amendment, whether by amended or supplemental pleading, can cure the deficiency. The subsequent cause of action that arose may only be subject of a different suit, but cannot be pleaded as a supplement to the complaint where no cause of action exists. Simply put, no amended or supplemental complaint is allowed. Q. On May 12, 2005, the plaintiff filed a complaint in the RTC of Quezon City for the collection of 250,000 pesos. The defendant filed a motion to dismiss the complaint on the ground that the court had no jurisdiction over the action since the claim amount of 250,000 pesos is within the exclusive jurisdiction of the Metropolitan Trial Court of Quezon City. Before the court could resolve the motion, the plaintiff, without leave of court, amended his complaint to allege a new cause of action, consisting in the inclusion of an additional amount of 200,000, thereby increasing his total claim to 450,000. The plaintiff thereafter filed his opposition to the motion to dismiss, claiming that the RTC has jurisdiction over his action. Rule on the motion, 2005. The motion to dismiss should be denied. Basic is the rule that a motion to dismiss is not a responsive pleading. Under the rules, a pleader may amend his pleading as a matter of right before the other party has served his responsive pleading. Section 2, Rule 10. The court, in allowing the amendment, would not be acting without jurisdiction because allowing an amendment as a matter of right does not require the exercise of discretion. Soledad versus Mamangun. Gumabay versus Berlin. Prudence Realty versus CA. Q. After an answer has been filed, can a plaintiff amend his complaint with leave of court by changing entirely the nature of the action? 2003. Yes. The present rules allow amendments substantially altering the nature of the cause of action. Section 3, Rule 10. Ears of Marcelino Pugobo versus Court of Appeals. This should only be true, however, when the substantial change or alteration in the cause of action or defense shall serve the higher interests of substantial justice and prevent delay and equally promote the laudable objective of the rules, which is to secure a just, speedy, and inexpensive disposition of every action and proceeding. Valenzuela versus Court of Appeals. Amendments to conform to or authorize presentation of evidence Q in a complaint for a sum of money filed before the MMRTC. Plaintiff did not mention or even just hint at any demand for payment made on defendant before commencing suit. During the trial, plaintiff duly offered Exhibit A in evidence for the stated purpose of proving the making of extrajudicial demand on defendant to pay 500,000 pesos, the subject of the suit. Exhibit A was a letter of demand for defendant to pay said sum of money within 10 days from receipt, addressed to and served on defendant some 2 months before suit has begun. Without objection from defendant, the court admitted Exhibit A in evidence. Was the court admission of Exhibit A in evidence erroneous or not? 2004. The court's admission of Exhibit A in evidence is not erroneous. It was admitted in evidence without objection on the part of the defendant. It should be treated as if it had been raised in the pleadings. The complaint may be amended to conform to the evidence, but if it is not so amended, it does not affect the result of the trial on this issue. Section 5, Rule 10. Effect of amended pleading Q. X, an illegitimate child of Y, celebrated her 18th birthday on May 2, 1996. A month before her birthday, Y died. The legitimate family of Y refused to recognize X as an illegitimate child of Y. After countless efforts to convince them, X filed on April 25, 2000 an action for recognition against Z, wife of Y. After C filed an answer on August 14, 2000, X filed a motion for leave to file an amended complaint and a motion to admit the said amended complaint in pleading the 3 legitimate children of Y. The trial court admitted the amended complaint on August 22, 2000. What is the effect of the admission of the amended complaint? Has the action of X prescribed? 2000. Answer: no. The action filed on April 25, 2000 is still within the 4-year prescriptive period, which started to run on May 2, 1996. The amended complaint in pleading the 3 legitimate children, though admitted on August 22, 2000 beyond the 4-year prescriptive period, retroacts to the date of the filing of the original complaint. Amendments in pleading new defendants retroact to the date of the filing of the complaint because they do not constitute a new cause of action. Versosa versus Court of Appeals. Summons. What is the effect of absence of summons in the judgment rendered in the case? 1999. A. The effect of the absence of summons on a judgment would make the judgment null and void because the court would not have jurisdiction over the person of the defendant. But if the defendant voluntarily appeared before the court, his appearance is equivalent to the service of summons. Section 20, Rule 14. Q. When the additional defendant is impleaded in the action, is it necessary that summons be served upon him? 1999. No. A defendant who was substituted for the deceased need be served with summons because it is the court which orders him as the legal representative of the deceased to appear and substitute the deceased. Substituted service. Q. A sued XX Corporation, XXC, a corporation organized under Philippine laws for a specific performance when the latter failed to deliver T-shirts to the former as stipulated in their contract of sale. Summons was served on the corporation's cashier and director. Would you consider service of summons on either officer sufficient? 1999. Summons on a domestic corporation through its cashier and director are not valid under present rules. Section 11, Rule 14. Q. Summons was issued by the MMRTC and actually received on time by defendant from his wife at their residence. The sheriff earlier that day had delivered the summons to her at said residence because defendant was not home at the time. The sheriff returned or proof of service filed with the court in some states that the summons with attached copy of the complaint was served on defendant at his residence through his wife, a person of suitable age and discretion, then residing therein. Defendant moved to dismiss on the ground that the court had no jurisdiction over his person, as there was no valid service of summons on him, because the sheriff return or proof of service does not show that the sheriff first made a genuine attempt to serve the summons on defendant personally before serving it through his wife. Is the motion to dismiss meritorious? What is the purpose of summons and by whom may it be served? Explained, 2004. A. The motion to dismiss is not meritorious because the defendant actually received the summons on time from his wife. Service on the wife was sufficient. Buticano v. Chua. It is the duty of the court to look into the sufficiency of the service. The sheriff's negligence in not stating in his return that he first made a genuine effort to serve the summons on the defendant should not prejudice the plaintiff. Mapa v. Court of Appeals. The purpose of the summons is to inform the defendant of the complaint filed against him and to enable the court to acquire jurisdiction over his person. It may be served by the sheriff or his deputy or any person authorized by the court.